I did use our electric typewriter to give you a little outline. Just to attack some of the later cases, we always have our 3A cases and what's it take to get over the hump for an adjudication. Is Section 1. We'll talk a little bit about TPR cases, some Indian Child Welfare Act cases, and some miscellaneous matters. The first couple go to finding adequate findings under risk of harm, generally speaking. The first one, Enrique G. Mom's home was ruled out as a possibility right off. Dad had been in the penitentiary for failure to pay about 26 grand of child support. House was not, or his home was unstable and deemed not appropriate, and it looked to the court that he was probably on his way back to the pen for that 26 grand that was not being reduced. And the risk of harm, all of that together was found sufficient for the adjudication. Dylan S., again, Dad didn't have a house, no legal source of income. Apparently he had some illegal sources. And he had mental illness, didn't take the prescribed medication for that. How many of those cases have we seen? And he missed visits. All of that combined for a sufficient basis for the adjudication. Patient's I. Mom needed an inpatient assessment and evaluation. Didn't say treatment necessarily, but that in and of itself was enough for the adjudication in that case. I thought the quote from that case: "The purpose of the adjudication phase of a juvenile proceeding is to protect the interest of the child, safety. The parent's rights are determined at the dispositional phase." That's a thing to keep in mind as we approach this. Emma J. This one, teenage girl, late in the sibling strip, reported the same sort of activity that was reported and addressed with earlier children. Included being hit in the head by Dad, go stand in the corner on one foot. Dad tried to explain it away by saying, "Oh, I didn't treat her any worse than I was treated when I was in the pen." That was deemed sufficient for an adjudication. Also, the court noted that the dad was verbally abusive to the caseworker. That sometimes helps for an adjudication. Shayla H. Dad had a history of physically and verbally abusing the mother in the presence of the children. Again, a potential risk of harm. As was stated earlier today, the potential for risk of harm in domestic violence situations is very great and has always been a good basis for adjudicating under 3A. Same thing with Antonio A. Jr. And again, that one had prior removals and prior terminations. And going to any questions on any 3A cases, and that's it. I was court ordered to make it quick. Just correct. Termination of parental rights cases. Obviously, failure to comply with rehab plans. 292.7, 15 of the last 22 is a good place for the court to hang its hat when there may or may not be questions as to whether or not the evidence is there to find in this case, mom missed visits, didn't get her evaluations that were ordered, refused UAs, and didn't maintain proper housing, stable housing, excuse me. But the court hung its hat on the 15 out of 22 for the termination. Dan and C is notable for the ruling that the state has no obligation to prove reasonable efforts to reunify when the bases for the TPR are abandonment and the 15 out of the 22. So you don't have to mess with it. Christopher C. And I've had a case like this, I don't know if you all have, but it's the one where you have the parent who doesn't comply with the rehab plan, is not the most controllable client in the world, and you get into court the first day and the parent acts out and goes out. But there you are. You've started your TPR trial, and you're sitting there, and your client has left. The trial court in Christopher C. did the same thing as the trial court did in the case where my client left me, and we proceeded with the TPR, and the court says that's fine, because the question is, do we have procedural due process? And when you've got the notice to the parent, particularly when there's presence at the beginning of the hearing, and his counsel is there, together with the fact that he's been advised of his rights, and by our judges multiple times, that's it. The parent's choice to leave is the parent's choice. This guy left because when the trial started, he apparently was slouching in his chair, and the judge told him not to slouch. So tell your clients to sit up straight, and they'll have a better chance at winning a TPR. Kenna S. is notable for the ruling that incarceration time shall not be excluded from the 1522 determination. I know there's always been some, well, what about that? The state took him away. But I think that's his own acts took him away. And also, see, in that same case I was talking about of mine where my client left me, took us 9 days to do the TPR hearing, even without my client. And of course that 9 days was over a period of several months. In Danny H., there was 13 months of trial, during which time Mom did everything she was supposed to under the rehab plan, made the visits, got good income, stabilized her living situation, got almost done with a 2-year college degree. Trial court terminated, and on appeal, says a party's consistent and substantial progress during the time it takes to try a TPR can make it error to terminate, especially if the process takes 17 months at least. 17 months under the TPR complaint and 13 months of actual trial, bifurcated, of course. Now, while the court in Kenna S. said that those days in jail count on the 15 out of 22, the court in Josiah T. said, absent evidence as to the length of sentence, incarceration in and of itself is not going to be enough to substantiate a TPR claim. So somebody should tell the court how long the parent's going to be in the clinic, is what it amounts to. And apparently that was a failure. Then the court said, well, when we have kids, we all take our chance. And in the interest of chance, they said, when you just can't tell by looking. And in that case, the parents separated prior to the birth of the child. When Dad found out that the child was born, he went to the hospital and looked at the baby. And the baby was white, blue-eyed, red hair. Chance's mother's husband was a black fellow. He said, that's not my kid. They had separated because Dad was not approving of Mom's lifestyle, using drugs and being a prostitute. And they figured that Mom and Dad, in their conversations, figured it was the product of one of her tricks. But when the TPR was filed, apparently Dad said, no, I want to be Dad. And the court said, and this was like a couple years later, the court said, no, you had your chance to, you could have, so to speak, there are innumerable ways to determine, and good ways to determine whether or not you were the father. And just looking and going to do it. You had your opportunity, and you blew it. Again, a sort of a risk of harm approach in that Bianca H. and Eternity H. Mom suffered mightily at the hands of the dad. Time and time again, they'd lost some kids. She then visited him in the pen, although she was saying she was having nothing to do with him. And when she kept re-establishing contact with the guy who had subjected her to this extreme physical violence, the court said that's good enough for a TPR. A couple of Indian Child Welfare Act cases. What's the burden of proof on adjudication under a NICWA case? Okay. Boom. I thought we were under the impression, generally speaking, that we had an increase with it. But the court in Lewis S. kind of indicates that, excuse me, yeah. Yeah, I may have lost where I was. No, that's M and J, sorry. We'll go to M and J. That it is, rather than clear and convincing, it's preponderance of the evidence, unless you're seeking to effect a foster care placement or termination of parental rights. Now, I don't know what that means. Does anybody?
It's a higher burden when it's a termination.
I'm sorry?
It's a higher burden for the termination only.
Yeah, I think this is not, okay, just for termination, yeah.
The preponderance of the evidence when you get the adjudication, but then if you're moving on to get the child in foster care, then you have to show that the child needs to go to foster care by clear and convincing, I think.
I agree.
Okay.
I thought the statute said it increased burden. The ICWA statute.
Well, that was kind of my question.
And I haven't been in this case, but I managed to take a look at it.
Yeah. Anyway, to me, it kind of confused where I thought things were in the past, but
I think that's right. I think that it's changed everybody's concept of what you actually had to do.
And I still thought that it was beyond a reasonable doubt for termination.
well, I think it is beyond a reasonable doubt for termination, but this is not termination.
You said, here it says clear and convincing only when
Okay.
seeking to affect foster
Or
care.
termination for,
Right. But it wouldn't be clear and convincing, it would be.
I believe it would be beyond a reasonable doubt too, Jim. Lewis S. Under Indian Child Welfare Act cases indicates that active efforts are not just suggestions. In an ICWA case, you can't just say, well, go do this, go do that. It's, here's how you do it, or we'll get you the transportation. There is a higher burden on the department, I suppose, and a higher burden on us to make sure that the department does provide actual active efforts, as opposed to thought processes. Any questions or comments on any of that? Okay. Miscellaneous things I thought were of interest. Interest of Dakota L. Even though you can go through a TPR without the client, the parent present, if they are there at the beginning, it is procedural due process, violation of procedural due process to proceed with a hearing in the absence of the parent and the parent's attorney, particularly when the parent's attorney isn't an attorney anymore. Hopefully none of us get into that position. Antonio O. and Caselaw O. Defining what parents' due process is, and they say it goes to adequate representation, notice of proceedings, and ability to cross-examine and participate in proceedings. What that was, that the father was a Mexican national. When the case was started, there was neglect on the part of the system. The Mexican consulate was not notified. And the father raised that as a due process argument and said, no, that's not due process. Interest of Americal T is, I noted that as it's one of the latest statements that we all look to when a parent fails to rehab. Quote, children cannot and should not be suspended in foster care or be made to await uncertain parental maturity. End quote. That old saw that is often relied upon. When we hear things like we heard today about addiction, we wonder if maturity is the real issue sometimes. That's what I had. Thank you.